To order, and without objection, the chair is authorized to declare recesses of the subcommittee at any time. Welcome to this morning's hearing on the Supreme Court's shadow docket. Before we begin, I would like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I will now recognize myself for an opening statement. Welcome to this subcommittee's first hearing of the 117th Congress on the topic of the Supreme Court's shadow docket. The Supreme Court is one of the nation's most vital institutions. Its decisions have consequences that are wide-ranging and far-reaching, and the public's ability to learn how and why those decisions were made is critical to maintaining open justice. This transparency is a foundational element of the Supreme Court's integrity. For many of the court's notable cases, we know how the majority reached its decision. We know which justices agree or disagree with the majority's opinion and why. And we have detailed briefing from the litigants and third parties about their views. Importantly, in most instances, this process gives the public months to scrutinize and understand the significant issues at bar and their potential impact. Yet not all of the court's work takes place so openly. There exists a segment of decisions on what is unofficially called the shadow docket. Coined by Professor William Baudet in 2015, the shadow docket comprises emergency orders and summary decisions not found on the court's main docket. Here, the justices make their decisions based on shorter than usual briefs, without oral arguments and under a tight timeline. The justices are also not required to publicly record which way they have voted. And as a result, the public has little or no insight into the court's decision-making. Despite the brevity of the court's consideration of cases on the shadow docket, the stakes are still high, sometimes a matter of life and death. Over the last year alone, decisions on the shadow docket have effectively ended the 2020 census count, cleared the way for the first federal executions in 17 years, and have covered some of the last administration's most controversial policies, such as the border wall, the travel ban, abortion, and transgender rights. Matters relating to or impacted by the COVID-19 pandemic are also on the shadow docket, including state election laws and state rules limiting attendance at places of worship. The shadow docket has expanded in recent years. We can point to a few reasons why. Among them, a large share of emergency requests during the Trump administration were at the request of the federal government. Such requests are not unprecedented, but the increase in volume certainly is. Under the Trump administration, the Solicitor General sought 5 times the number of such emergency or extraordinary petitions than the George W. Bush and Obama administrations combined. The divisiveness of these decisions seems to have risen in tandem. An increasing number of emergency orders on the shadow docket are decided by a narrow 5-4 margin, often among or along ideological lines. The onslaught of these important decisions has prompted concerns over the Supreme Court's transparency, as well as the executive branch's role in shaping the Supreme Court's agenda through the shadow docket. We are not here to doubt the justices' hard work, but in order for justice to be fair, justice must be open. The court's recent shadow docket decisions demonstrate that at a minimum, more transparency is needed. knowing why the justices selected certain cases, how each of them voted, and their reasoning is indispensable to the public's trust in the court's integrity. Today's hearing marks the first time that Congress has explored the shadow docket in depth. As scholars and practitioners before the court, each of today's witnesses brings important insight into what the shadow docket has become, its impact on the law and on the American people, and what could or should be done. I look forward to an informative and productive dialogue. And it is now my pleasure to recognize the ranking member of the subcommittee, the gentleman from California, Mr. Issa, for his opening statement.
Thank you, Mr. Chairman, and thank you for holding this very timely and important hearing today. At this time, I'd like to ask unanimous consent to enter into the record a number of articles from one of our witnesses, Professor Morley, so that can be circulated to the staff before his testimony.
Without objection, so ordered.
Also at this time, I'd like to ask unanimous consent that a member of the full committee, but not a member of the subcommittee, Congresswoman Sparks, be allowed to attend, and time permitting, if there's a yielding from another member, be able to ask a question.
Without objection, so ordered.
Thank you, Mr. Chairman. Mr. Chairman, as often occurs in this committee and in this subcommittee, we have both sharp disagreement between the various members here on the dais and a great deal of agreement. Much of what you just said in your opening statement would be paired perfectly with my views. But there are some items that I think are critical that we ensure, as we see what's wrong with shadow docket, that we also appreciate what is right. Many would say that a last-minute decision by the court not to stay the execution of a prisoner is inherently wrong. However, the alternative could easily be a simple refusal to grant cert, therefore condemning the prisoner without even one last look. When we consider over the years the court's very important decisions that they have taken on when and how you can execute a convicted person who's been sentenced to death, in fact, it's those very novel last-minute calls, such as somebody's diminished capacity and the like, that have come to pass. So I think it is critical that we do make sure that we continue to have the justices feel that they can take far more than the 70 cases they take on their formal docket. Notwithstanding that, I share with you considerable concern that during the last administration, this five-fold, as you said, increase occurred. I would say that one of the things that I hope we explore in detail today is the question of whether or not the problem is at the High Court or even at the Solicitor General, but rather at the fair interpretation of what an Article III judge at a district is entitled to rule. None of us here today would doubt that a federal judge, as to the case before him and the plaintiffs before him, has authority to enjoin in every part of the United States, including its territories, within his jurisdiction. The question really is, in many cases, does he have a right to enjoin the administration for their conduct related to anyone not currently a plaintiff in front of the court? This is a question that I believe the Supreme Court must answer. If they fail to answer, or perhaps if the answer is incomplete, it falls to this committee and to this subcommittee to look at a restatement or reform of the breadth of these types of decisions. I, for one, believe that we do have an opportunity to work together on a bipartisan basis over the next 2 years to craft good and understandable decisions. And I think particularly since the administration has recently changed and, in fact, control of the Congress has changed, we could contrast how we felt during the Trump administration when they repeatedly went to the High Court versus the possibility that in the weeks to come, one or more judges around the country might in fact enjoin the administration in a very similar but reversed role, and they may be running to the court. If that's the case, if in fact this very large increase in the load by the court continues, but in a reverse role, then I think there could be no choice but either the court to act or us to act. Further, I believe that in the case of many of the decisions that are now popping up, such as almost every death penalty case having an 11th hour novel review, that there needs to be a greater level of certainty as to when and how a pleading can go, so that in fact we reduce the load to the court. Lastly, I believe that one of your points that is most valid is that although it is unlikely for us to get an expeditious improvement in the transparency of the court, that we have the ability to both ask for, study, and if necessary, require that in the period after a decision, but in the clearness of those days or weeks to follow, that we have a more full and complete reporting. I believe we have an opportunity as a committee to look into a number of bipartisan, mutually selected examples and write the court and ask them to give us, in those specific cases that are of public interest, for a more complete answer, including the process for the voting, who voted, and particularly some of the underlying elements. If we choose cases wisely, I believe we then begin to have the building blocks for what we would ask for and expect in post-mortem of these last minute and often, as is often said, dead of night decisions. So, Mr. Chairman, I'd ask unanimous consent that the rest of my opening statement be placed into the record and that we be able to get to our witnesses. Thank you, Mr. Chairman. I think you have to unmute.
Thank you, Mr. Isa. I now recognize the distinguished ranking member of the full committee, the gentleman from Ohio, Mr. Jordan, for his opening statement. But I might add, without objection, the remainder of your statement will be entered into the record. And with that, Mr. Jordan. Mr. Jordan, are you with us? And are you unmuted?
Mr. Chairman, we don't hear you again.
Okay, apparently Mr. Jordan is not on the line. So at this point, I will proceed to the introduction of the panel of witnesses. And our first witness is Professor Stephen Vladek, who holds the Charles Allen Wright Chair in Federal Courts at the University of Texas School of Law. He has argued before the U.S. Supreme Court, the Texas Supreme Court, and lower civilian and military courts. In addition to teaching, Professor Vladek is an elected member of the American Law Institute, a distinguished scholar at the Robert S. Strauss Center for International Security and Law, a senior editor of the peer-reviewed Journal of National Security Law and Policy, and a Supreme Court Fellow at the Constitution Project. He is also the co-host of the National Security Law podcast, is CNN's Supreme Court analyst, and is the executive editor of the Just Security blog and a senior editor of the Lawfare blog. Professor Vladek received his BA from Amherst College, and his JD from Yale Law School. And if you would give me just 1 second. Welcome, Professor Vladek. And next, I would like to introduce Mr. Amir Ali, who is a civil rights lawyer who litigates issues of national importance in federal courts across the country, including the U.S. Supreme Court. He is director of the Washington, D.C. office of the MacArthur Justice Center, a premier national civil rights law firm, and deputy director of the organization's Supreme Court and appellate program. Mr. Ali also teaches at Harvard Law School, where he directs the law school's criminal justice appellate clinic. Mr. Ali has successfully argued multiple cases in the U.S. Supreme Court and has represented several people under death sentences before the U.S. Supreme Court. Mr. Ali received his BS in software engineering from the University of Waterloo and his JD from Harvard Law School, and I'd like to extend a warm welcome to Mr. Ali. Professor Michael Morley joined Florida State University College of Law in 2018, where he teaches and writes in the areas of election law, constitutional law, remedies, and the federal courts. Before joining FSU Law, Professor Morley was a Clemenceau Fellow and lecturer in law at Harvard Law School. Prior to his experience in academia, he served in government as special assistant to the General Counsel of the Army at the Pentagon, as well as a law clerk on the U.S. Court of Appeals for the 11th Circuit. He also worked as an associate at Williams & Connolly, LLP, and the Supreme Court and Appellate Group at Winston & Strawn, LLP, both in Washington, D.C. Professor Morley earned his JD from Yale Law School in 2003. Welcome, Professor Morley. Solicitor General Lauren Ali Khan is the Solicitor General of the District of Columbia. She oversees administrative, civil, and criminal appeals in the D.C. Court of Appeals, the U.S. Court of Appeals for the D.C. Circuit, and the U.S. Supreme Court. Prior to this, Solicitor General Ali Khan focused on Supreme Court and appellate litigation at the law firm O'Melveny and Myers. She also served as a Bristow Fellow in the Office of the Solicitor General at the U.S. Department of Justice and was a Temple Bar Scholar in London, England, where she worked with the Deputy President of the Supreme Court of the United Kingdom, Solicitor General Ali Khan, clerked for the U.S. Court of Appeals for the Third Circuit and for the U.S. District Court for the Eastern District of Pennsylvania. She earned her bachelor's degree from Bard College, Simon's Rock, and her JD from Georgetown University Law School. Welcome, Solicitor General Ali Khan. Before proceeding with testimony, I hereby remind the witnesses that all of your written and oral statements made to the subcommittee in connection with this hearing are subject to 18 U.S.C. Section 1001. Please note that your written statements will be entered into the record in its entirety, and I ask you to summarize your testimony in 5 minutes. To help you stay within that time frame, there is a timing light in WebEx. When the light switches from green to yellow, you will have 1 minute to conclude your testimony, and when the light turns to red, it signals that your 5 minutes have expired. Professor Vladek, you may now begin.
Thank you, Mr. Chairman, Ranking Member Issa, distinguished members of the subcommittee. Although the shadow docket has existed for as long as there has been a Supreme Court, there's no disputing that it has grown in prominence in the last 4 years, not because the total number of these orders has increased, but because the court is acting far more aggressively in these cases than in the past, including in staying lower court injunctions of state and federal government action, in lifting stays of executions that lower courts have imposed, which is quite distinct, of course, from refusing to grant a stay of execution, and in directly enjoining state officials in cases in which multiple lower courts have already refused to do so. As I explained in my written testimony, the Trump administration helped to precipitate some of this uptick But the shadow docket is about much more than just the federal government. And even in federal cases, it has been about much more than nationwide injunctions. In the last 2 weeks alone, we've seen 4 major shadow docket rulings, 3 blocked state COVID-related restrictions, 1 refused to vacate a lower court injunction blocking an Alabama execution. None involve the federal government. Not only are the justices using the shadow docket to change the status quo with far greater frequency, but as Chairman Johnson noted, they're publicly dividing in these cases far more sharply than before. During the October 2017 term, Justice Kennedy's last, only 2 shadow docket orders provoked 4 public dissents. Over the next 2 terms, there were 20. During the October 2019 term alone, there were almost as many public 5-4 shadow docket rulings, 11, as there were 5-4 marriage rulings, 12. Why has this happened? So I think it's a long story, and I try to tell some of it in my written statement. No single development adequately explains it, including the rise of nationwide injunctions. Rather, I think it stems from a confluence of factors, including the Supreme Court's changing composition and the ascendancy of an idiosyncratic view about when emergency relief is appropriate. Indeed, it's no coincidence, in my view, that the brakes have truly come off since the retirement of Justice Kennedy and the death of Justice Ginsburg. Nor can it be denied that this uptick has had enormous real-world consequences. Mr. Ali and Solicitor General Ali Khan are both going to speak to some of the many ways in which these rulings have affected individual Americans and government-wide policymaking. But even for those who think the court has nevertheless reached the right results in these cases, there are still numerous respects in which we should find this uptick troubling. First, having more and more of the court's significant decisions handed down through unseen, unsigned, and unexplained orders raises serious legitimacy questions, since such rulings bear none of the hallmarks of principled judicial decision-making. Second, they leave lower courts and government officials to speculate, and as we have seen increasingly, disagree as to what the law actually is going forward. Third, they invert the ordinary flow of litigation, leading the court to prematurely, if not unnecessarily, resolve serious constitutional questions based upon undeveloped, or at the very least underdeveloped, factual records. And fourth, they increasingly appear to be coming at the expense of the merits docket, where the court decided the fewest merits cases last term since the Civil War, and is on pace to decide the second fewest since the Civil War this term. Obviously, the best solution would come from the justices themselves, pushing more of these issues to the merits docket, providing more explanation for those major disputes that must be resolved through orders. I don't disagree that there will always be at least some need for a shadow docket, but not all of these cases really are emergencies. If we take, for example, the court's most recent order in the California cases, that order came late on a Friday night, 6 days after the briefing had been complete. The court has expedited merits cases in less time in its history. In any event, Congress is hardly powerless. And although I'm wary of efforts to prevent the court from using the shadow docket, both for normative reasons and in the extreme for constitutional ones, I believe that there is a productive conversation to be had about how Congress might take pressure off of the shadow docket. And I suggest some possibilities in my written statement. Of course, my list is hardly exhaustive. Smarter people will have better ideas. The far more important point is that the shadow docket is something to which we should all be paying more attention. If nothing else, then, today's hearing is a welcome step in that direction. Thank you for the opportunity to testify, and I look forward to your questions.
Excuse me, I'm speaking without unmuting. Thank you for your testimony, Professor Vladek. And Mr. Ali, the floor is yours, 5 minutes.
Thank you, Mr. Chairman, Ranking Member Issa, members of the subcommittee. Thank you for inviting me to testify today. The very description of what we're talking about, the shadow docket, makes clear that it does not usually get public attention, and I applaud the subcommittee for exploring it today. I plan to focus my testimony on one of the most frequently recurring issues on the shadow docket, the execution of a human being by the state. This is the most solemn act our legal system authorizes. Mr. Vladek explained how the shadow docket resolves issues on undeveloped facts and uncertain law. Those features are at their most disturbing when we are talking about executions. When it comes to ending someone's life, there is no do-over. Mr. Vladek described the legitimacy problem of a judicial system that operates on unsigned and unexplained orders. When the matter is life or death, the need to ensure transparency and public confidence in our legal system is at its apex. Yet presently, the Supreme Court decides weighty execution issues in the middle of the night, often upon hours or even just minutes of having the briefing. In the most disturbing of these cases, the Supreme Court allows executions to go forward without explanation after a lower court, which has had substantially more time to consider the evidence and arguments, has concluded that the impending execution likely violates the Constitution and laws of our country. I think it's important to pause for a second and think about that. When the Supreme Court reverses without any explanation, a person is executed even though the only analysis we have on the public record says the execution would violate the Constitution. Let me give a clear example of the shadow docket's arbitrary treatment of this ultimate punishment. It involves a story about three men, a Muslim, a Buddhist, and a Christian. Each of these men sought the very same thing, to die with a religious advisor of their own faith by their side to guide them through the final moments of their life. When Dominique Hakim Marcel Ray, a devout Muslim, asked for an imam by his side, he was told no. No imams, but he could have a Christian chaplain in the execution chamber. A lower court stayed Mr. Ray's execution and found he had a powerful claim under the Establishment Clause, which prevents the government from preferring certain religions over others. The court also found that he brought this claim as quickly as he possibly could have. In an unsigned order, the Supreme Court reversed. It did not address the lower court's conclusions, and Mr. Ray was executed that night without any spiritual advisor to pray with him. 1 month later, Patrick Henry Murphy, a Buddhist man, asked for a Buddhist priest by his side. Like Mr. Ray, he was told no. He could only have an advisor from religions that the state had chosen. This time, the Supreme Court reached the opposite conclusion. In an unsigned two-sentence order, it stopped Mr. Murphy's execution. The one justice who provided an explanation said it would have been okay to deny a Buddhist priest as long as the prison denied Christian advisors as well. Fast forward to just last week. Willie B. Smith, a Christian man who requested a pastor in the execution chamber. In response, the state took the Supreme Court's latest advice: no spiritual advisors of any kind. Once again, the Supreme Court shifts course. In another unsigned order without legal analysis, the court stopped Mr. Smith's execution unless he was provided with a Christian pastor in the chamber. This unexplained disparity is dangerous. Consider the potentially devastating public impression of our justice system. The Muslim prisoner, he may be executed without an advisor. The Buddhist man, well, his advisor can't be selectively excluded like the Muslim person's, but may be taken away if done right. And when the Christian man comes to court, well, his right to have a pastor present, that can't be taken away. My point today is not that that is how the Supreme Court viewed these cases. I don't think it viewed the cases in such terms at the time. My point is that the use of the shadow docket means we have no idea what justified the disparate treatment of these men. And when the difference is life or death, even the appearance of arbitrary decision-making risks the very legitimacy of our legal system. Thank you, and I look forward to your questions.
Thank you, Mr. Ali. Next, we will go to Mr. Morley. Mr. Morley, 5 minutes. The floor is yours.
Thank you very much. Mr. Chairman, Ranking Member Issa, members of the subcommittee, thank you for this opportunity to testify. It's a privilege to have this chance to speak with you again. Today's hearing is on the Supreme Court's shadow docket. It's a term that sounds mysterious and foreboding. In fact, it's simply a term that a law professor coined a few years ago, as the chairman mentioned, for the Supreme Court's orders list. All of the documents, briefs, and orders on the orders list are a matter of public record and accessible through the Supreme Court's website. One shortcoming of the orders list is that the court sometimes does not reveal how particular justices voted on the matter. Certain aspects of the shadow docket have received increased attention in recent years, particularly stays of lower court injunctions and other rulings, which prevent federal district courts' orders from taking immediate effect, writs of mandamus to lower courts, ordering them to perform certain actions, and grants of certiorari before judgment, in which the Supreme Court agrees to hear a case before the Court of Appeals has had the opportunity to rule on the matter. I'd like to offer a few reflections on these developments. First, lower courts' greater use of so-called nationwide injunctions has been at least one contributing factor to the growth of the shadow docket. Professor Vladek's Harvard Law Review article reveals that, as of January 2017, about half of the Supreme Court's stays and 2/3 of its grants of certiorari before judgment as of that time arose from cases involving nationwide injunctions. I would implore this committee to abandon the term nationwide injunction, as it's very misleading in trying to consider this issue, since the main concern with these orders is not their geographic applicability. Instead, we should focus on the distinction between plaintiff-oriented injunctions and defendant-oriented injunctions. A plaintiff-oriented injunction is appropriately tailored to redressing the harm suffered by the plaintiffs before the court in a particular case. A defendant-oriented injunction, in contrast, is an order that unnecessarily goes further, enforcing the rights of third-party non-litigants throughout the nation and potentially even the world who are not before the court. When a federal court issues a nationwide defendant-oriented injunction, it completely disables the defendant agency or officials from enforcing the challenged legal provisions against anyone anywhere, including people in other jurisdictions whose claims would otherwise be adjudicated by the law of other circuits. Because such orders can impact agency operations throughout the nation, suspend programs the government believes furthers important interests, and affect potentially millions of right holders, the court has a tremendous impetus to respond to such sweeping relief with extraordinary measures like stays or certiorari before judgment. I've written extensively about many of the concerns defendant-oriented injunctions raise. Among them, they raise serious justiciability concerns under Article 3. They raise concerns under Rule 23 in giving effectively class-wide relief without a plaintiff class certified. They have unfairly asymmetric preclusion effects. They magnify the effects of forum shopping. They are in tension with the hierarchical, decentralized structure of the federal judiciary, as well as the Supreme Court's own ruling in United States versus Mendoza that the government should be permitted to relitigate public law issues rather than being bound by the first adverse district court ruling. One way to limit the growth of the shadow docket would be restricting nationwide defendant-oriented injunctions. Secondly, the legislative history underlying the Supreme Court's current jurisdictional provisions confirms that Congress intended immediate Supreme Court review to be available when federal district courts struck down important federal laws as unconstitutional. Throughout much of the 20th century, constitutional cases were adjudicated by 3-judge federal district court panels. Their rulings could be appealed as of right directly to the US Supreme Court. In 1988, when Congress completed the lengthy process of amending these jurisdictional provisions to shift most constitutional cases back to the ordinary appellate process, this committee issued a report, the Judiciary Committee issued a report emphasizing that these amendments, quote, increase the importance of certiorari before judgment, quote, as a means of securing an expeditious and definitive resolution of statutory unconstitutionality by the Supreme Court. The committee report concluded that the Judiciary Committee contemplates that the court will give appropriate weight to the elimination of direct review when deciding whether to grant certiorari before judgment where a lower court has invalidated a federal law. So at least in that respect, the court is acting consistently with the congressional intent. Thank you very much.
Thank you, Mr. Professor Morley. And next, we will go to Solicitor General Ali Khan for 5 minutes. Ms. Khan.
Chairman Johnson, Ranking Member Issa, and distinguished members of the subcommittee, thank you for the opportunity to appear before you today. As the Solicitor General for the District of Columbia, I have experienced firsthand the increasing frequency with which the Supreme Court disposes of contentious or novel legal issues on the shadow docket. These orders, which address issues of paramount public importance, including immigration, the election, the death penalty, and more, have enormous practical consequences well beyond the litigants involved. For example, despite being styled as interim decisions, several shadow docket orders effectively decided the rules, procedures, and deadlines that would apply for votes cast in the 2020 election. In one unsigned 2-paragraph decision issued less than a month before Election Day, the Supreme Court reinstated South Carolina's requirement that mail-in ballots be signed in the presence of another individual, despite the need for social distancing in light of COVID. In another, the court reinstated Alabama's ban on curbside voting. Because of the timing, these rulings were effectively the last word on the matter. With the increase in important and controversial orders on the shadow docket, we are seeing 2 patterns that deviate from the court's merits cases. First, high-profile shadow docket decisions split along the court's perceived partisan lines at a much higher rate than merits cases. Second, shadow docket decisions often lack majority reasoning, full opinions, and a record of the justices' individual votes. Indeed, many of the shadow docket orders contain no more than 1 paragraph explaining the disposition, meaning that the public knows very little about what the court is thinking and why. As a general matter, the public overwhelmingly respects the court's pronouncements as authoritative, a triumph largely attributable to the court's strict adherence to a procedural framework that ensures transparency and consistency across cases. The defining feature of the shadow docket is that it lacks these procedures, and this carries several risks. First, the shadow docket presents challenging conditions under which to make major decisions. Lawyers produce their best work when they have opportunities to perform research, consider facts and arguments, and consult colleagues. Supreme Court advocates and even Supreme Court justices are no exception. But the accelerated pace of the shadow docket means that the court confronts novel, controversial issues with diminished deliberative tools and far fewer viewpoints. When ruling on an emergency request, the court may lack a developed record, confront claims unconstrained by the narrowing process of certiorari, or face arguments that lack full consideration through the reasoned opinions of multiple appellate courts. There's also no opportunity for oral argument, which deprives the justices of the opportunity to clarify the scope of claims, the practical consequences of a particular result, and the specifics of the record. And of particular importance to institutional litigants like the District of Columbia, there are also diminished opportunities for the court to hear the views of amici curiae, which can situate a dispute in its wider legal and socio-political context. The shadow docket also limits the ability of the members of the court to formally deliberate. Last April, for example, the court ruled 5-4 to vacate a stay of execution. And in a sharply worded dissent, Justice Breyer revealed that he had asked his colleagues to wait until the next morning so that they could discuss the case at their conference. Instead, the court vacated the stay overnight, and the execution occurred before the justices could meet to discuss. Second, shadow docket orders provide little information on how or why the court reached a result. In particular, we do not always know how the justices voted. Indeed, just last week, a mystery justice joined Justices Breyer, Sotomayor, Kagan, and Barrett to halt an execution. And even when the vote tally is clear, shadow docket orders often contain little explanation of why issues of principle dictate the result. The inscrutability of shadow docket orders creates significant practical hurdles. While the precedential weight of these orders is disputed, when the Supreme Court speaks, legal institutions and stakeholders listen. Lower courts work hard to faithfully apply the Supreme Court's instructions, but with limited guidance, they can struggle to divine workable rules from the court's minimal reasoning. And this lack of clarity from the Supreme Court is problematic for states and regulated parties that strive to accurately implement the court's directives. The court's consideration of pandemic restrictions is one example. Recently, the court issued a fractured shadow docket decision, striking down California's prohibition on indoor worship, but allowing certain capacity restrictions. The order provides no consensus on what animated the court's conclusion, and as Justice Kagan noted in dissent, provided no guidance to other jurisdictions confronting the same issue. I want to close by emphasizing a high-level, but I think important point. Issues with the shadow docket are related to the court's appellate jurisdiction, meaning its supervisory function over the lower courts. As Article 3 confirms, Congress has the authority to superintend the Supreme Court's exercise of appellate jurisdiction and regulate the lower courts, and Congress has done so before, both altering the cases the Supreme Court reviews, such as capital cases, and the standards lower courts must apply when issuing certain relief, like in the Prison Litigation Reform Act. Accordingly, there's a path for legislation if Congress deems it appropriate. Thank you for the opportunity, and I look forward to your questions.
Thank you, General Ali Khan. I will now proceed under the 5-minute rule with questions, and I will begin by recognizing myself Professor Vladek, you mentioned in your testimony that there is a traditional four-factor test that the court has historically applied in deciding to grant emergency relief. How has the court's application of this test shifted in recent years? And what impact has that had on the types of emergency relief the court has decided to grant?
It's a great question, Mr. Chairman. The traditional four factors, just really quickly, are first, the likelihood that the Supreme Court would grant certiorari when the case came before it on a proper appeal. Second, that the court would actually side with the applying party on the merits, the likelihood of success on the merits. Third, that the appealing party would suffer irreparable harm without emergency relief pending their appeal. And fourth, that the balance of the equities weighs in favor of such relief, that there wouldn't be an even greater harm worked on other parties, even non-parties, by providing the relief being sought. And Mr. Chairman, the Supreme Court hasn't acknowledged any shift in those four factors, but I do think we have seen the second factor become overly dominant, where the justices are almost exclusively focused on the merits. A very good example of this, Solicitor General Ali Khan referred to the California COVID decision from 2 weeks ago, what I think was colloquially known as South Bay 2. And in that decision, there are multiple opinions concurring and dissenting in the injunction the court issues, none of which speak about the factors, none of which actually talk about whether there was in fact a likelihood of granting cert, whether there was irreparable harm to the applicants from California's restrictions if they were allowed to remain in place, or the balancing of the equities, the potential downsides of enjoining California's indoor worship restrictions for the duration of the appeal. And Mr. Chairman, I think it's the disappearance of that consideration, the disappearance of the balance of the equities has really turned these cases into just merits decisions, coming at an incredibly premature stage where none of the other conventional equitable concerns about the impact on other parties, about irreparable harm, are really playing the role that they have historically. That's the shift I think we've seen, and the best evidence of it is in individual opinions by individual justices, most prominently the Chief Justices in Chambers' opinion in a case called Maryland versus King in 2012.
Thank you. Solicitor General Ali Khan, in your written testimony, you mentioned that the shadow docket and the court's lack of clarity have been problematic for jurisdictions like the District of Columbia that are striving to implement the court's COVID-19 directives. Can you elaborate on the unclear guidance that has come from the court and how that has impacted the District of Columbia and other jurisdictions?
Absolutely. Jurisdictions like the District of Columbia want to make sure that they are adhering to the court's pronouncements. But there's some real controversy as to whether these shadow docket rulings have precedential effect, and if so, which ones do. At the same time, when the Supreme Court has invalidated a similar provision, even if it's in a situation that's not precedential, you pay attention. And so if you don't have the reasoning behind the decision, so for example, in the South Bay 2 case, we don't have a sense of why there's the ban itself for areas that had the highest COVID transmission rates was not allowed, but why certain capacity restrictions would be allowed. So if we were to approach these restrictions on worship in light of COVID in areas that were particularly ravaged, we'd have a very hard time understanding of, could we ban it in certain circumstances? What could the appropriate capacity restrictions be? And because we don't have any consensus on those issues from the court, it really leaves us at a guessing game of what was animating their decision and how it would apply to us.
Thank you. Mr. Ali, in your testimony, you write that a person may be executed even though the only reasoned judicial decision on the books tells us that there was a serious likelihood the execution violates the laws of the country, of our country. In a matter of life and death, that is a particularly astounding consequence. You proposed a narrow fix that would import a standard of review for such cases. Can you elaborate on this proposed standard and explain how things may have turned out differently for some of the cases you've described had there been such a standard? And if you can do so within about 30 seconds, I'd appreciate it.
Yes, and hopefully I can revisit it again, but I think that there's an easy solution here that is something that Congress does routinely, which is provide standards for courts to apply. And the example I give in my written testimony is in the statute EDPA. governing decisions made by state courts. It's in Title 28 of the U.S. Code 2254D, and it attaches great deference to those decisions. And I think in this instance, where we have courts finding errors, finding problems with the legality of an impending execution, similar deferential standards of review ought to be in place here. And I think this should be seen as taking pressure off of the court, helping the court avoid the public confidence issues that I spoke about earlier.
Thank you. With that, I will now call upon the ranking member, Mr. Issa, for 5 minutes questions.
Thank you, Mr. Chairman. I didn't plan on asking this question, but I think it needs to be asked since I'm a Californian, and I'll start with Mr. Morley, Professor Morley. In the case of a decision in California by Governor Newsom that, as an executive, shutting down churches outright while leaving, for example, pot dispensaries and a host of other retail facilities open, and including restaurants for much of that time. Do you feel that the Solicitor General's theory that there's no guidance when they ruled that essentially you could limit the capacity, but based on a similarity of restaurants and so on, but you couldn't outright ban First Amendment rights to religion?
So there's two ways of thinking about how judicial opinions make law. Right? The first is the top-down approach, where the Supreme Court articulates rules and principles and guidelines and just based on a particular case, tries to anticipate future potential cases and craft a rule that's responsive to that, so then future parties facing comparable situations know exactly what to do. A different approach is more of a common law approach, where the court just looks at a particular situation before it, says, yes, this is good, no, this is bad, doesn't try to articulate broad sweeping principles. Right. One reason for that would be judicial modesty, judicial uncertainty, that if there's a situation where the court thinks it might be a fast fact-changing situation, where in the case of COVID, for example, developments with either the new mutations or the spread of vaccines, either positive or negative developments might materially change the facts on the ground. The court doesn't want to be laying out hard and fast principles for then future courts to stick to, but rather by taking situations on a case-by-case basis and just having particular situations that it upholds, particular situations that it enjoins. Litigants can then look at that in a more common law fashion, and states like California can look at those rulings in a more common law fashion and try and conform their conduct. So it's really a matter of the court potentially trying to minimize judicial error by having as narrow of a ruling as possible. And the narrowest ruling on a particular set of facts, of course, is simply just affirming or reversing.
Sure. Yeah. Well, and they seem to be pretty clear to me that the governor was simply wrong. In your testimony, I think you made a very strong point. I'd like to have you elaborate on it, at least as to what are called nationwide injunctions. If in fact this body, the House of Representatives, were to either restate or clarify, or the High Court were to clarify that a judge's jurisdiction is only as to the plaintiffs in front of them, recognizing that a class would be different than an individual, would this mitigate a great many, or at least some of those cases that went to the High Court, because they effectively shut down the entire United States as to the administration?
Yes, Mr. Ranking Member. One portion of the shadow docket, and again, it's certainly not the whole thing, but one of the contributing factors of the shadow docket is the increasing use of so-called nationwide injunctions, or as I think focusing more on the right issue, defendant-oriented injunctions. And so if district courts were to limit their relief just to the particular plaintiffs before them, if they didn't purport to enjoin federal statutes, regulations, executive orders, or for litigants throughout the entire nation, or third-party non-litigants, I should say, throughout the entire nation, there would be far less of a need for the Supreme Court to immediately hear a case. There would be far less of a need for the Supreme Court to step in with these extraordinary emergency types of relief that we see through the shadow docket.
Lastly, am I out of time, Mr. Chairman? Still have time. Lastly, historically, this body, the Congress, created the Fed Circuit in no small matter because the U.S. Supreme Court was swamped, as were the district or the Circuit Court of Appeal, were swamped with reversals of patent cases and found themselves without the unique expertise. Do you believe that the Congress, and this subcommittee particularly, should begin looking at specialized appellate systems for many of these problems? And I'll just quickly say death penalty cases and nationwide injunctions as just two of them.
That would certainly be one potential response if you have a single court such as the U.S. Court of Appeals for the Federal Circuit that has nationwide jurisdiction over issues. The scope of injunctions would become far less salient because its rulings would have national effect as a matter of stare decisis. There are certainly drawbacks to having such nationwide specialized courts as well that I'd be happy to. I see my time has elapsed.
Lastly, for all of the witnesses.
And time has elapsed, but proceed, Mr. Issa.
Thank you. I'll be very brief.
You're about 1 minute over.
Thank you.
1 minute and 10 seconds.
Thank you, Mr. Chairman. Briefly, would you all agree that if all of the cases handled by the shadow docket were to be taken up by the High Court would not be able to handle that many cases, and therefore we do have to either maintain the shadow docket or find some way for a deliberative body to consider more of these cases?
Congressman Issa, I'll just say really quickly, I don't think that's true if you consider the relevant set, not every order the Supreme Court issues, but the categories we're talking about. The Supreme Court heard 53 arguments last year. As recently as 15 years ago, they were hearing well over 100. And so I think, the notion that the court is appropriately hearing 53 merits cases and can't handle 85 or 90 is belied even by recent history.
Thank you, Mr. Chairman.
Gentleman is welcome. Next, we will proceed to the gentleman from Arizona, Mr. Stanton, for 5 minutes.
Thank you very much, Mr. Chairman. Over the last few years, we've increasingly seen in our country a tale of two Supreme Courts, one that we're all familiar with, one in which oral arguments are made before the justices, one in which parties who have an interest in the case can make their case heard too, and one in which the rationale for the court's decision sees the light of day. But another one has emerged in recent years. It's one where decisions with sweeping implications are made in the dark, in the shadows, with rationale and legal reasoning hidden from the public. The so-called shadow docket was created for emergency situations where a party had to show irreparable harm to skip the line and forego the traditional path to the U.S. Supreme Court. That's why it's been so often used to handle death penalty cases. But now it's used much more broadly, used strategically by litigants of a certain ideology who didn't like or agree with a district court decision to skip the appellate courts and go straight to a more sympathetic Supreme Court. Lower court decisions on election integrity, for example, are undermined by the Supreme Court without a hearing and without any rationale shared with the American people. That's not how it's supposed to work. Why is this such an important issue? Because the Supreme Court plays an essential role in our constitutional system of government as part of our system of checks and balances. When the court does not provide any rationale, any explanation for its decision, does not record its vote, does not allow for the affected parties to make their case, it is the court that is going unchecked. And the American people are left to question what is happening behind closed doors. Concerns have been raised that the Supreme Court, through the shadow docket, sometimes seems to ignore its own professed standards of giving deference to district court findings in reaching its decisions. Professor Vladek, do you agree with this? And if so, what justifies second-guessing the trier of fact like this?
Yeah, I mean, Congressman Stan, I think it's a fair point in some of the cases we've seen. This is going to be, I think, a broken record that you're going to hear from some of the witnesses today. It's hard to make definitive statements about why the court has done things and about specific things the court has done because we so rarely get, signed opinions for the court in this context. But, I think Mr. Ali can speak to some of the death penalty cases where there were factual findings by district courts that were not credited or were at least just sort of completely ignored when the case came to the Supreme Court. I'll just say, on that front, Congressman, I don't think that problem is limited to the shadow docket. I mean, I think we have seen the Supreme Court, even in merits cases, show increasingly less respect, whether deserved or not, right, to lower courts, even in plenary appeals.
That's great. And in Solicitor General Ali Khan or Mr. Ali, what is the impact of bypassing the normal standard of deference given to the district court factual findings in this manner?
I think that the impact in death penalty cases, and particularly execution issues, is immense for public confidence. I can give an example of a recent execution in the case of Dustin Higgs. In that case, you had a Maryland district court question the very legality of executing Mr. Higgs. The Fourth Circuit looked at the issue and said, this is actually a difficult issue. We need 12 more days. That's what they were asking for, 12 more days to have an expedited argument in which we consider this claim. And the Supreme Court reached down and stopped the Fourth Circuit from even taking those 12 days. And when we look back at the historical record, I think it's going to look like a real stain in terms of public confidence in the operation of what is often referred to as the machinery of death.
Professor Vladek, some may suggest that justices shouldn't be held to the decisions in emergency orders because there wasn't a lot of time to decide and they don't have the full benefit of a hearing and they don't give their reasoning, so they aren't bound for future cases. What do you say in response to that?
I mean, that's certainly what the Supreme Court has said, Congressman. I think the problem, and this goes back to the colloquy between Congressman Issa and Mr. Morley and Professor Morley, the Supreme Court may have that view about itself. It is telling lower courts otherwise. And so the COVID restriction, the California indoor worship case that Congressman Issa was talking about, 3 days after that decision, the court issued something called a GVR, a grant, vacate, and remand, in a different case called Gish versus Newsom, which I cite in my written statement, where the court told the district court to go back and try again in light of its decision in the South Bay 2 case. And Congressman, its decision in the South Bay 2 case was an unsigned order with no analysis. And so, it very well may be the case that the Supreme Court doesn't feel like anything it says on the shadow docket is binding it. It's clearly the case that it views what it's saying on the shadow docket, or not saying as the case may be, as binding lower courts.
Gentlemen's time.
Thank you so much, Mr. Chairman. Yield back.
Thank you. Next, we will hear from the gentleman from Ohio, Mr. Shabbat, for 5 minutes.
Thank you, Mr. Chairman, for holding this really very interesting meeting on this interesting topic. Professor Morley, as you know, there are nearly 700 federal district court judges throughout the country and territories, any one of whom could issue a nationwide injunction to block the executive branch from acting in a certain way. I note that the majority has scheduled a hearing next week, I believe, which will presumably make the case for additional lower court judges who could issue even more injunctions against things that they disagree with. Now, as we know, during the Trump administration, the previous administration, federal district courts issued nationwide injunctions, for example, stopping construction of our southern border wall, stopping efforts to limit travel from high security risk nations into the United States, and preventing the Food and Drug Administration from enforcing in-person dispensing and signature requirements for abortion-inducing drugs during the coronavirus pandemic. In my view, nationwide injunctions place far too much power in the hands of a single judge, ultimately allowing that one judge to control how the federal government will act towards all Americans, not just towards the aggrieved party in a particular case or controversy. Until the last 50 years or so, it's my understanding that these types of injunctions were rarely used, very seldom used. In fact, it's only been in the last few years that they've been used extensively to really upend the authority of our former president. This has created a system where politically motivated attorneys can essentially forum shop for an activist judge who will help them achieve their political goals. It seems highly problematic that actions taken by Congress or the president can be stymied by a single activist judge, but they certainly are. Professor Morley, how significant a problem is this forum shopping, and have I essentially set out the situation and the problems as many people see them at this point in time?
Yes, Congressman, that's absolutely correct. One of the consequences of allowing federal courts to issue nationwide defendant-oriented injunctions, completely barring the federal government from enforcing a legal provision, is that, as you explained, it exacerbates the consequences of forum shopping. Because if a plaintiff goes to an ideologically sympathetic judge, that judge's interpretation of the law then is given binding force for right holders throughout the entire nation, including in other circuits where other litigants' claims would ordinarily be judged and adjudicated under the law of those other circuits. And so what you systematically see is, depending on the ideological valence of the case, right, there are certain jurisdictions that conservative plaintiffs will go to when they want to seek a nationwide defendant-oriented injunction against what they view to be progressive measures. There are certain jurisdictions that left-leaning plaintiffs will go to when they're seeking a nationwide defendant-oriented injunction against what they perceive to be conservative measures. And you're having constitutional law driven by judges who don't reflect a fair cross-section of the federal judiciary, who deviate substantially from the median federal judge, so to speak. And in terms of both the choices of cases that wind up being brought, the way in which the district court adjudicates those cases, the opinions that then are sent up for review, this affects not only the practical consequences of the court's ruling, but it has an impact on what the court is actually holding in those opinions. So you're absolutely right. The effects of forum shopping go far beyond just impacting a particular case to shaping constitutional law for the nation.
Thank you. I'm about out of time. So just to sum it up, to me,
30 seconds left.
Pardon me?
30 seconds.
Okay. It seems inherently unfair to allow one judge in a specific jurisdiction to issue a ruling which essentially binds the entire nation when there are a huge number of judges in other districts who would come to just the opposite point of view. And we may have hated that happening in the previous administration. I think the Democrats are going to come to hate that in this particular administration. And so we do need to work together in a bipartisan manner to do something about this. And I yield back my time. Thank you.
I thank the gentleman. Next, we will go to the gentleman from Hawaii, Mr. Liu, for 5 minutes. Mr. Liu.
Thank you, Mr. Chairman, for calling this hearing on this very important issue. And the issue today isn't really about how lower courts or appellate courts happen to look at injunctions and how the Supreme Court looks at injunctions. It's actually about the Supreme Court issuing orders in the dark and not even putting their names on it. So one of the witnesses had testified that a mystery justice has signed on to a particular order. Can you just explain a little more what happened in that specific issue?
Of course. So that was a situation in which there was a decision to stay in execution, and 4 justices put their name on it, but it takes 5 justices to rule on something. And so there was clearly someone lurking in the background that cast that vote, but did not want to be accountable for it. And so Justice Scalia wrote extensively about why having public records of one's votes is very important in the system, because it protects, and I talked about this in my written testimony, someone from taking one position one day and the polar opposite position the next day. And so when we don't have visibility and insight into what votes the justices are casting, because they don't have to give them to us unless they want to, then we end up with a situation where we don't know who the majority of the court is on any particular case.
And has the court or any justices ever offered any rationales for why they believe they can sign on to orders without disclosing their name?
So I think this gets back to something that Professor Vladek was alluding to, which is on the general orders docket, most of the decisions that are made are routine docket management questions that don't end up needing to have any judge's name on it. Some of them can be disposed of by one justice, some of them might go to the full court, but they don't need to have an opinion, have any explanation. And so the problem that we're seeing is that these quasi-merits cases are now being disposed of on the orders docket. And so these normal processes for the orders docket of not having a name, not having an opinion, not having the full process and briefing are now being used in these cases that should be on a merits docket or should at least have more process, including having justices announce what their votes are, having majority opinions that provide reasoning, and having concurring and dissenting opinions as are appropriate.
And does Congress have the power to write legislation requiring justices to sign their names to quasi-merits orders or decisions?
I think I defer to Professor Vladek on this question.
Thank you, Ms. Alicon, for your answers. Professor Vladek?
Yeah, Congressman, I think it's a close question. Congress has never tried to before, and even if it might be within Congress's raw constitutional power, I'm not sure it would have the desired result. I mean, there have been proposals for a while to have the court disclose the vote count on grants of certiorari or denials of certiorari. And I think what the court would do if any proposal was ever enacted into law is have the public vote count always be unanimous, even if the private vote count wasn't. I think the better, way to think about reform, and Mr. Ali talked about this in his opening statement, is to think about ways of taking pressure off the shadow docket. To Solicitor General Alicon's point about how these are quasi-merits adjudications, try to figure out if there are ways to help the court actually have merit adjudications if these cases really present circumstances warranting that kind of dramatic expedition. Congressman, we saw that already this term with the apportionment case, which the court got all the way onto its merits docket and decided in a signed decision pretty quickly. And so I think, the reform conversation, ought to start with ways of taking pressure off the shadow docket before it moves to, punishing the justices or prohibiting certain kinds of behavior.
So thank you. Solicitor General Alicon, back to that issue you talked about where the Mr. Justice signed on. Why is it that we knew the names of the other justices in that particular case?
Because they disclosed them. So in cases where they want to write separately, they want to provide, even if it's one sentence or one paragraph of analysis, the justice that is writing it will announce who they are, and then anyone who joins that will add their name to it as well. So in this mystery justice case, we have someone that agreed with the ultimate result, which was to grant the stay, but did not subscribe to the opinion or the order that had been published in that matter.
Thank you. And then one last question, Professor Vladek, what if there was a congressional law that said, because death penalty cases are so important and not reversible if the execution happens, that when you have orders in those cases, they've all got to disclose who the justices are?
Yeah, I think that would be a narrow approach. I think another way I would be thinking about death penalty cases, Congressman, is something Mr. Ali alluded to, which is perhaps restoring the Supreme Court's mandatory appellate jurisdiction in such cases, where it actually has to hear those appeals on the merits and therefore can't simply dispose of them on the shadow docket. We already have at least one example of a federal court that's jurisdiction is otherwise discretionary, but must hear capital cases. That's the Court of Appeals for the Armed Forces. I don't know why we couldn't talk about doing the same thing for the U.S. Supreme Court.
Thank you. Gentlemen's time
you.
has expired. Next, we will go to the distinguished gentleman from Texas, Mr. Gomet, for 5 minutes. Mr. Gomet.
Thank you, Mr. Chairman, and thanks to our witnesses. I am a big fan of justices, judges and justices making clear who's making the decision. And I would welcome, reforms that required that, unlike one of our witnesses I think the Congress does have authority to do such a thing, require such a thing, since, as my constitutional law professor said many years ago, there's only one federal court that is mentioned in the Constitution. All others rely on Congress for their very existence. We brought them into the world. We can take them out. We can create rules that are appropriate for them. I do take some offense to the term shadow docket to the point that they're not in the shadow. They are legitimate, basically should be considered, I think, preliminary judgments. But I do have, again, the concern people ought to know who it is that's formulating a decision. I've had problem with per curiam en banc as a way to hide who actually wrote a decision. I would like to see who wrote those decisions. But when it comes to this docket that's the subject of the hearing today, there are times when particularly the factor mentioned regarding irreparable harm requires quick action. And there is not time when you have a rogue federal judge that decides to take on and negate all the knowledge and information the executive branch and the president have and make his own decision. Professor Morley, speaking hypothetically, if China were to know that it had a potential pandemic disease and it had plane loads of people wanting to leave the area that potentially had the disease and fly to the United States, and some federal judge says the president can't have a temporary travel ban, we need to welcome those people. I'm going to overrule the travel ban, not just national effect, but internationally. Would that kind of situation justify a decision quickly by the quick docket of the Supreme Court rather than having a long drawn out process of applying for certiorari?
Yes, Congressman, under the scenario that you laid out there, there would certainly be a very strong argument that having a potential pandemic spread, if you know people right from a particular area where you have a highly infectious disease being spread, once they're allowed into the country, right, once they're allowed into contact with the general public, right, you can't unring that bell, right? Once the virus is spread, even if a court later on then were to reverse that ruling, were to try to undo that ruling, the court can't order the virus out of people's bodies. And so, yes, that would be exactly the sort of situation where the Supreme Court would be likely to find that there was irreparable harm, where there would be a balance of hardships tilting sharply in the government's favor. And I should add, that's exactly the sort of situation I would suggest that the House Judiciary Committee was contemplating, where when it shifted constitutional litigation away from direct appeals to the Supreme Court and back to the usual appellate process that most other cases go through, the House Judiciary Committee emphasized that we are not trying to stop the court from getting involved when there's a need to directly do so, where a federal law or other federal measure has been enjoined.
Well, thank you. And of course, the unprecedented numbers has been pointed out, having maybe 27 of these type cases in the whole 20th century and 55 just in the first 3 years of the Trump administration is a clear indication consistent with the Democrats refusing to acknowledge the legitimacy of the 2016 election and the legitimacy of the president. It was lawfare on display, and it was certainly appropriate for the Supreme Court to step in and say, wait, this isn't right. And I appreciate your time today. Thank you. I yield back.
I thank the gentleman. Next, we will go to the gentle lady from California, as is the gentleman from who I misidentified as coming from Hawaii, Mr. Liu. He's from California also. I recognize the gentle lady from California, Mrs. Lofgren, for 5 minutes.
Thank you very much, Mr. Chairman. And although Mr. Gohmert and I don't agree on a lot of things, I do actually agree with his uh, observation that calling this the shadow docket probably is unnecessarily pejorative. But there are still issues that I think are of concern. And one of the things that struck me is that several of the Trump administration's requests for extraordinary relief really relate to disputes about discovery in district courts. And for example, litigation over the census and the DACA cases. And usually district courts, when it comes to evidentiary and discovery, have wide discretion to make decisions. And it struck me as unusual or even odd that the court would intervene at this stage of the proceedings. I'm wondering, Professor Vladeck, were these decisions unusual? What are the problems with the highest court getting involved in district court cases at this stage of the game?
Yeah, Congressman, I do think they were unusual in the sense that one cannot find many prior examples of the Supreme Court issuing writs of mandamus in a couple of cases, or sort of hinting at issue writs of mandamus, at the Supreme Court issuing cert before judgment, the Supreme Court blocking in order to take deposition testimony from a cabinet secretary. You know, I think, Congresswoman, there are defenders of the administration who would say that district courts had been taking unusual steps to in discovery against the government witnesses. All I'd say in response to that is two things. First, I think the government witnesses were behaving remarkably deceptively in a couple of those cases. But second, this again underscores the point that if the Supreme Court thinks lower courts are misapplying the relevant legal standards when deciding when they can and can't take discovery of cabinet secretaries and other senior government officials, it ought to say so. And it ought to issue an opinion that says, here are the circumstances in which it's appropriate to depose someone like Secretary Ross, for example, and here are the circumstances where it's not, as opposed to leaving us to guess when it's appropriate, when it's not. One last point very quickly, Congresswoman, in the Ross example specifically, the Supreme Court went out of its way to issue multiple grants of extraordinary relief to try to get the case up very quickly on the question of whether the district judge could rely on extra record evidence. It even set that issue for oral argument. And the district court had never actually relied on extra record evidence. Indeed, his final decision was based solely on the administrative record. So it was all for naught, which goes again to why this is not just, I think, unhelpful and not telling us what's going on, but oftentimes unnecessary in the sense that we never get to the actual harm the government was claiming.
I know that my time is running out, but I would just say that, we have concerns about transparency, but it really goes to two things. One, the credibility of the court, and it's absolutely important that the court have credibility in its in the land, and transparency relates to that, but also transparency in terms of the implementation of decision making. And I was interested in the ranking member's comment about the COVID religion cases. But I think the court's decision making there fell so short because it was not clear what they were doing. And I'll give you an example right now in my county, Santa Clara County. There were restrictions, but they were not related to the type of activity. Whether you were a church or a gym or whatever, it had to do with occupation standards and air and the like. And yet there is ambiguity on whether the Supreme Court really meant to exempt religious organizations from rules about COVID that related to all organizations. So they've created a mess here in a way. And the mess really is serious because the virus can kill people. And I do think that their procedures fall far short here. And I am very interested, Mr. Chairman, in what kind of thoughtful deliberation we might have to put some guide rails on this so we can protect the reputation of the court and make clear the decision making and take action that will require the court in some of these very important cases to have more transparency and a more deliberative process than sometimes has been shown, causing confusion in the land. And with that, Mr. Chairman, thank you for recognizing me, and I would yield back.
I thank the gentlelady. Her point is well taken. We will now go to the gentleman from Louisiana, Mr. Johnson, for 5 minutes. And Mr. Johnson, you may want to unmute. Hearing no response from Mr. Johnson, he may not be on the line. I'm not looking at the list. We will now go to the gentleman or gentlelady from Wisconsin, Mr. or Ms. Tiffany, for 5 minutes. And I'm sorry, we have not formally met yet. It's Mr. Tiffany, but Mr. Tiffany is apparently not on the line either. So we shall next go to the gentleman from Kentucky, Mr. Massey, for 5 minutes.
Thank you, Mr. Chairman. I think that we also would benefit from knowing which judges ruled in which way in these cases. But before I jump to that conclusion, which seems obvious that we would want that transparency, are there any witnesses who can think of a benefit to having the judges be anonymous in these extraordinary cases that require them to rule quickly?
Not at all. I mean, if it is going to be a merits determination, I think that the public needs to know who is in the majority and who is not. And that's consistent with how they normally treat merits cases. It's just this sort of vagary that these merits decisions or quasi-merits decisions are being made on a docket that is historically used for routine, pedestrian and procedural orders that we're seeing this problem. But I think that judges and academics on both sides of the spectrum would think that there is a real interest in knowing who is voting how.
It seems to me to set up sort of a perverse incentive to take these cases on in this setting instead of the merit-based track of cases. If they wanted to remain anonymous, then there would be more incentive to take the case under this situation. Also, I don't know if this is practical or not, but it would also restore the incentive to hear these cases in the right sort of setting. Would it make sense, or would it even be possible for judges to go back after quickly ruling to flesh out sort of the opinions? And how would Congress go about requiring that? We couldn't require a certain number of paragraphs, for instance. But is there any way that you could imagine, any of the witnesses, frankly, where the judges could still act quickly, but then go back and do the work? It would set up an incentive where they're going to have to do just as much work and be just as transparent under this quick situation than they would under a typical merit-based hearing. Any of the witnesses are welcome to answer that.
Congressman, you may be familiar with the World War II era case of ex parte Quirin. This was the famous Nazi saboteurs case in the U.S. Supreme Court, where the Supreme Court did exactly that, where it issued a very, very short per curiam order allowing the military commission trial of the saboteurs to go forward. And then I think it was about 2 months later, after 6 of the 8 saboteurs had been executed, the court finally issued an opinion setting forth the rationale. And there's, I think, a fairly broad consensus that was, as Justice Scalia put it, not the court's finest hour, that it's actually a problematic setup when the court is actually writing opinions after they've done the thing that matters to try to explain why they did the thing in the past. I think the far better approach, and this is, I think, something you're hearing consistently from me and Mr. Ali and Solicitor General Ali Khan, is to give the court more of an ability to hear these cases on their merits quickly. I mean, we have examples. Bush versus Gore, the court went from granting the case to a merits decision in 3 days. The Pentagon Papers case, it was a week. The court has the ability to move very quickly, even on its merits docket. It has just fallen out of practice. And I think one of the questions is how we can create incentives for the court to return to that.
Right.
Yeah,
So
if I
it sounds
could, just in the death penalty context, I think it would be particularly problematic to have explanations come
okay.
afterwards.
Okay, I didn't think it would work. I just wanted to hear your opinion on that. Professor Morley, what are the most critical problems that you see raised by defendant-oriented nationwide injunctions?
Most basically, there's strong Article 3 problems. There's a question as to whether a plaintiff has standing to ask a court to invalidate a law or to enjoin a law for third-party non-litigants. Right? A plaintiff typically has standing only to enforce its own rights, only to assert its own rights. And so under the court's standing doctrine, there's a strong argument, in my view, that the plaintiff doesn't have standing and a court accordingly doesn't have jurisdiction to grant relief that's unnecessary to redress the harm to that plaintiff that's tailored for the benefit of third-party non-litigants. As I had mentioned before, we already have a mechanism. If a plaintiff wants to enforce the rights of third parties, to bring them before the court through the class action device, and in particular, Rule 23b2 was adopted specifically to allow civil rights class actions in order to enforce the rights of the broad classes of people. And most basically, they're contrary to the structure, the way that Congress has chosen to structure the federal judicial system. Under the Everts Act of 1891, Congress chose to create separate circuits with distinct bodies of law. If Congress wanted the first judge to rule on an issue to give that opinion the force of law throughout the nation, Congress could have structured the judiciary that way, but it chose not to.
I want
Gentlemen's
to
time has
thank the
expired.
witnesses and yield back.
Thank you. I thank the gentleman. Next, we will hear from the illustrious gentleman from Tennessee, Mr. Cohen, for 5 minutes.
Thank you. I appreciate the illustrious chairman of the subcommittee, Mr. Johnson. Professor Vladlen, and maybe one of the other witnesses would be better to ask, I don't know. Do you believe that most of these decisions are made because of the desire for anonymity, the desire for alacrity, or difficulty in the work product fitting into the time available to the court?
Congressman, it's a fair question, and all I can do is speculate. But I think it's probably the last of those most of all. But I don't think it is the anonymity that is driving the bus with regard to the rise of the shadow docket. I think it's just a salutary benefit for some of the justices. But I think then the question becomes, do we really accept that all of these cases present the kind of emergent circumstances that require that kind of compressed schedule? I mean, I'll just note there was a very significant shadow docket ruling right before in mid-January about mifeprex, about medicinal abortions, where the application from the federal government had been briefed in August, and the decision finally comes down in January. That doesn't strike me as an emergency, Congressman. And so I think, one of the things we've seen in the last 4 years, there will always be cases that present real emergencies that cannot be avoided. But we've seen the sort of idea of an emergency slide a bit, where now, cases that the court is sitting on for perhaps weeks are still being handled through its procedures designed for expediency in circumstances where expediency was not necessary.
So you said the latter, meaning that they don't have enough time to hear the cases. Is that what you think is their situation? They're doing this because of a failure of the Congress to modernize and reform the court to give the adequate amount of justices to be able to adequately hear the cases?
So I think that the size of the court is probably a different conversation for a different time. I do think that there's quite a lot of play in the joints of timelines, Congressman, in how long parties have to appeal, in how the party that won below can slow things down. And I do think one of the reforms Congress can and should consider to take pressure off of the shadow docket would be identifying a particular class of cases where those timelines ought to be significantly compressed. And those can include cases in which state or federal policies are subject to an injunction from a lower court. Those can include capital cases where the parties really do have to move quickly. Not necessarily a matter of hours, Congressman, but certainly a matter of days and weeks, as opposed to the very, I think, generous and conservative schedule that applies to most Supreme Court appeals.
While you're exactly right that this is not necessarily the topic of this discussion, and it is its own hearing, are you familiar with the increase in the court's cases over the last 20, 30 years and the limited amount of time they have to give justice to the amount of work they have to do?
I mean, the docket, I actually think that the overall docket in the Supreme Court, I think has not increased dramatically in the last 20 or 30 years. I think in the lower courts, we've seen, I think, more of that, which I think is also why there's, I think, a stronger argument for, and I think this committee is even considering it, for whether there ought to be new lower court judgeships. I'll just say, Congressman, to me, the problem we're seeing in the last 4 years is not a problem of an inadequate number of justices. Right? It's a problem of a court for which it has become too, in Justice Sotomayor's words, reflexive to grant emergency relief in circumstances in which in the past the court would have been far more skeptical.
Professor Ali Khan, do you agree the Supreme Court's got enough time? And do you agree the circuit courts need maybe to be expanded and reformed to meet the caseload?
Yeah, I do, Congressman. So I think Professor Vladek had alluded to this before, but the court is hearing fewer merits cases than ever. And so they could easily translate this kind of 20 to 30 odd cases that we're talking about as the problematic shadow docket cases onto a merits calendar, and I think get that work done pretty quickly. As for the lower courts, yes, I think that there's a lot of work out there talking about the delays that we're seeing in federal courts and in courts of appeals due to the uptick in litigation and a lack of resources. And so I do think, reprogramming resources to the district court or the courts of appeals, whether in the form of judges or court personnel like law clerks, would be very helpful.
Thank you. Mr. Ali, do you have an opinion about the courts and the need for more to adequately address the justice of the 21st century?
Yeah, I would say that this actually makes even more urgent the conversation we're having today. I'd come back to Representative Liu's question about deference to fact-finding. Here we have the very busy lower court judges we're talking about holding hearings, hearing evidence from witnesses and testimony, issuing opinions, and then making fact findings as they're supposed to do. And when it gets up to the Supreme Court, after all of that work has been done and the actual standards are considered in writing, it's swept aside. Unsigned, unreasoned opinion. And so I think it just makes the whole process all the more offensive.
Thank each of you. Now you balance of my time.
I thank the gentleman. We will next go to the gentleman from North Carolina, Mr. Bishop, for 5 minutes.
Thank you, Mr. Chairman. Mr. Vladek, as I was listening to the testimony and questions so far, and it's pretty late in the hearing, I want to focus on the question of whether or not some might have an interest in limiting the ability of the Supreme Court to act in a summary fashion, because that would augment the power of lower courts to be a little less supervised. So we have a hierarchical court system. For the rule of law to prevail, lower courts have to acquiesce in what the Supreme Court decides, and they have to, it seems to me, be of more circumscribed power than that court. Morley, in his testimony, describes nationwide defendant-oriented injunctions that exceed lower court power and can undermine the functioning of the circuit court system. He points out the possibility of forum shopping that could give rise to cause district court judges who are more ideologically extreme to handle a disproportionate number of cases. And if it seems to me also that it stands to reason that if numerous lower courts could, in a sheer volume of cases, flout or fail to acquiesce to the Supreme Court, they could essentially sabotage its supervisory capacity, its supervisory function, unless that court could act in a summary fashion, just by bogging it down. And I also, in the case of the South Bay II case and the other religious cases that have arisen, they've arisen, it seems to me, if that, to the extent that caused an uptick in the shadow docket, as you call it, arisen from an historically unprecedented situation of local orders to prohibit millions of people from attending church, which is, sort of a fundamentally unusual situation. So I was looking at the end of your testimony, your written testimony, about the things that you might do to take the pressure off the shadow docket. And it seems to me that those treat the symptom of the shadow docket maybe rather than any of those causes. Like you could limit or terminate nationwide injunctive power of district court judges. You could implement a system to discipline lower court judges who flout or refuse to acquiesce in authority from the Supreme Court, and particularly, Solicitor General Ali Khan spoke about the South Carolina case that arose concerning the absentee ballot deadline. I think it was a violation of Purcell, so as one example. So all of your reforms that you suggested focus on limiting the ability of the Supreme Court to do this kind of summary activity or shadow docket or orders list activity. And I wonder what you think of the alternative instead that Professor Morley suggests of attacking the problem at its cause, which is limiting the sort of emergency problems that spring up from the lower courts.
So, Congressman, with respect, I think perhaps I haven't conveyed my proposals accurately in my testimony, because I don't think that's a fair summary of them. I mean, I don't believe I have suggested that we should limit the court's power to issue these decisions. I think the question is, how can we create circumstances where the court will feel less of an obligation to do so?
What about the other side of it, attacking the supply side, if you will, to say, to evaluate whether the problems are coming up? And what do you think maybe of his thesis, Mr. Morley's thesis, about the nationwide defendant-oriented objection?
Yeah, I mean, so I think, Congressman, I'd like to say just two brief things. First, I think insofar as nationwide injunctions or defendant-oriented injunctions are the problem, there are other ways to solve them, right? For example, I propose in my testimony the possibility of allowing the federal government to transfer any lawsuit seeking such relief to the DC District Court so that the federal government has it. But more broadly, and I think this is the critical point, nationwide injunctions are not a majority, and they're not even a significant plurality of the source of these shadow docket rulings. And so insofar as there's concern about district judges running amok, I am not here to defend those district judges. I am here to suggest that the problem is not district judges with regard to the shadow docket, because, Congressman, keep in mind, the only way these cases get to the Supreme Court is not just that the district court has ruled in a particular way, but that the Court of Appeals has refused to upset that ruling. So now we're not just talking about a single forum-selected, hand-picked district judge. We're talking about an entire Court of Appeals not disturbing that decision before it gets to the Supreme Court.
Professor Morley, I've only got about 20 seconds remaining. Do you have any response to that general line of questioning? Just like to get your thoughts.
Sure. I mean, I would just add one of the reasons why I think it's better to focus on defendant-oriented injunctions rather than nationwide is because a lot of these orders dealt with state laws, right? And so for orders that apply to third-party non-litigants across the state rather than the nation, if you're targeting defendant-oriented injunctions, you'll pick up those as well.
All right. I yield back.
Gentleman's time has expired. And at this time, I will call upon the learned gentleman from New York, Mr. Jones, for 5 minutes.
Thank you, Mr. Chairman. You are too kind. I will say that in a discussion about the Supreme Court's rogue, highly secretive process called the shadow docket, we have spent more time, or at least my Republican colleagues have, talking about the process by which nationwide injunctions are issued. I say this as a former candidate just a few months ago who successfully obtained a nationwide injunction, and that I think helped to save our democracy and ensure a free and fair election. I successfully, along with co-plaintiffs, obtained an injunction to suspend Postmaster General DeJoy's proposed operational changes that were meant to undermine that election, which was largely facilitated by mail-in ballots. In any event, many thanks to all of our witnesses for helping to shed light on the Supreme Court shadow docket. I'm troubled that the court decides many of our nation's most consequential cases, from elections to executions, with such speed and such secrecy. Many of these shadow docket decisions seem to betray our constitutional commitment to due process. And I especially want to thank the litigators appearing before us, Mr. Ali, Solicitor General Ali Khan, and of course, Professor Vladek. As a lawyer, I recognize that it takes great courage to question the court when you know you may have to argue future cases before the justices. Professor Morley, you've written that you see nothing partisan in the Trump administration's unprecedented exploitation of the shadow docket and the Supreme Court's disproportionate 5-4 rulings in Trump's favor. But to me, the partisanship of this far-right court is obvious. Take immigration, for example. When President Obama wanted to protect immigrants by expanding deferred action for childhood arrivals, DACA, and also creating deferred action for parents of Americans, DAPA, the Supreme Court did nothing as the lower court stopped him. When President Trump wanted to ban Muslims and build the wall, the Supreme Court issued special shadow docket decisions to let him get away with it. Or consider equity for transgender people. When President Obama directed public schools to provide equitable accommodations for transgender students, the Supreme Court did nothing as the lower court stopped him. But when President Trump wanted to ban transgender people from serving in the military, the Supreme Court issued a special shadow docket decision to let him get away with it. Or think about the right to vote. When President Obama asked the Supreme Court to stop Texas from disenfranchising voters of color, one of the few times that President Obama even asked for emergency relief, the court let Texas disenfranchise those voters anyway. But when President Trump's Republican allies waged war on our democracy amidst a pandemic, the court issued special shadow docket decisions putting voters' lives at risk in places like Alabama, Florida, Idaho, Oregon, South Carolina, Texas, and twice in Wisconsin. So Professor Morley, do you see any pattern of right-wing bias in these shadow docket decisions? A simple yes or no, please.
Well, Congressman, that wasn't what I wrote. I was referring specifically to the use of certiorari before judgment. I said that one tool was consistent with the legislative intent of embodied in the House Judiciary Committee's report. I never made a broad defense of the Trump administration's use of the shadow docket.
I so appreciate that response. Professor Vladlen, let me turn to you. As you testify, the Supreme Court issues thousands of shadow docket decisions every year, unsigned orders that almost never include any reasoning at all. And most often, they're one or two sentences. You're on Twitter, Mr. Vladlen, so maybe you can help me figure this out. To your knowledge, are any Supreme Court justices active on Twitter?
Not so far as we know, Congressman. Although there is a widely circulating rumor that at least one of the justices has a burner account that she uses to follow people like us. Unfortunately.
Interesting. And are Supreme Court opinions limited to 280 characters?
No, although sometimes in some of these orders it seems like they are. And I think that's, it seems like it is not hard, even in a quick turning case, Congressman, right, for the court to write more than 280 characters. I think the issue is, we're increasingly seeing 1, 2, 3 sentence orders, not just in the thousands of cases that no one would raise a stink about, but in cases where the court is actually disrupting the status quo and affecting, for better or for worse, thousands of people's lives.
Then, Professor Vladlen, is there any good reason the Supreme Court should be deciding matters of life and death in anonymous rulings the length of tweets? Donald Trump governed by tweet too, but at least he had the decency to use his real name on his account. Thank you, Mr. Chairman. I yield my time.
I thank the gentleman. We shall now go to the esteemed gentleman from Wisconsin, Mr. Fitzgerald. I'm sorry, for 5 minutes.
Thank you, Mr. Chair. Fascinating discussion. I don't have any specific questions right now, so I would just yield back my time to the ranking member if needed. Thank you.
I appreciate that. And let me briefly follow up and explore a little further with Professor Morley and the other witnesses. You're currently having a bit of a debate about the number of merit cases taken. What do you think would be the maximum number of these cases that could be moved to merit? There's been a lot of discussion about, not all of them need to be done immediately and so on. I certainly look at the death penalty cases, for example, where these pleadings come in the final days or hours, almost always. And if that one fails, there's usually one right behind it. Would you really ever be able to put, for example, the death penalty reevaluation onto a merit calendar without the judges essentially working 24/7?
And if I may interrupt, Mr. Issa, would you please allow us to see you?
I'm so sorry.
That's quite okay.
I didn't even realize I was off. I apologize. I'm so sorry.
Thank you.
So I think it varies dramatically by the nature of the case, right? Different cases are going to involve different types of irreparable harm. Different cases are going to be on different timelines. With the election-related cases, for example, where the court was dealing with COVID-related changes that had been ordered by lower courts, right? Obviously, right, the election was on a date certain, and so that wasn't something where if the court wanted to get involved, or if the court even just wanted to send a signal to lower courts about the types of modifications that would or would not be appropriate, or the circumstances under which modifications would or wouldn't be appropriate, it didn't really have the option of waiting for cases to go through the ordinary process. In terms of a highly expedited procedure of the type, some of the witnesses referred to Bush v. Gore, New York Times v. Sullivan. Certainly the Supreme Court can do that, but there's only a limited number of times in a given year you can do that, right? Having intense, 18-hour days, 7 days a week, putting all your attention in one case, you can do that occasionally. You can do that periodically, but that can't be right part of standard operating procedure. That can't be even, I would suggest, a monthly occurrence.
So it'd be fair to say that every litigant believes his should be the exception, but not every litigant can be pleased.
That's probably true, Congressman.
Okay, lastly, I want to ask the other witnesses, because it is one of those major questions that won't happen overnight. Using the Fed Circuit as historic for patents and trademarks, patents specifically, and now looking at some of these cases, could each of you opine on what cases could be either forced to be moved to the district, in other words, compelled to be brought in the District of Columbia and taken through that process, or ones in which the appellate could be to a court of specific jurisdiction based on the desire for them to consider merit without burdening the court.
Congressman, I'll take a stab at both of those. I mean, I think there would be nothing beyond Congress's power to provide the DC District Court with either exclusive or concurrent jurisdiction in any lawsuit against the federal government. And so whether you wanted to mandate that those cases go to DC or give the federal government the choice of litigating them in a particular district court or moving them, I think those would be within Congress's power. I am not, Congressman, a fan of specialized courts. I think the federal circuit's actually a pretty good example of why they don't always work the way Congress intends. The federal circuit's track record in the Supreme Court as of late has not been, I think, what anyone would call good. And so, I think the specialized courts strike me as sort of the wrong solution to the wrong problem.
So coming back very, very briefly, would it be fair then to say that that you support the Biden administration being able to, if they're sued based on one of their actions somewhere in the country other than the District of Columbia, being given the authority to move and have that removed to the District of Columbia, thus binding themselves to a national decision?
Not just the Biden administration, Congressman, I would think consistently across any executive branch. I think that would be, especially if that was an option and not a mandate, I think that would be a way of preserving lots of things we could all probably agree on as salutary values.
Gentleman's
Thank
time
you.
has
Thank you, Mr.
expired.
Chairman.
I thank the gentleman. We will next go to the well-studied gentle lady from North Carolina, Ms. Ross, for 5 minutes.
Thank you very much, Mr. A couple of questions on where you seem to be going when you were responding about is an emergency and how the court may have strayed from what an emergency is, whether there's truly irreparable harm going on. And could you talk a little bit about whether you think the court has moved too far away from considering something that's a true emergency and how it might be better to have categories of things that could be decided quickly? Obviously, a death penalty case would be at the top of the list, versus things that should not be allowed to be considered emergencies.
Sure. Congressman, you broke up a little, so I assume that question's for me. The
Yes, yeah, I'm sorry.
on the emergency point, I mean, I think so. There will always be, and I hope my colloquy with Congressman Bishop drove this home. There will always be cases where the court has to act exceedingly expeditiously. I think that what we've seen in the last couple of years is more and more cases where the court is sitting on these issues for a week, for 2 weeks, for, you know, in the Mithraprex case, 5 months, and still issuing a so-called, you know, a ruling that is bound by its emergency procedures. I'm wary of drawing a bright line between what is an emergency and what isn't. Because I think part of what slows down the decision-making process in these cases is that the justices themselves are taking some time to write their opinions. But I do think that, you know, the taking pressure off of the emergency, right? And the death penalty cases do not have to be 11th hour appeals. We can provide more mechanisms for prisoners to bring claims perhaps before an execution date is set, right? Just ways of sort of making clear to the justices that they don't need to treat everything as an emergency, even if we might disagree about where the line is. So that to me is the concern, is that, you know, the concept has clearly expanded. I don't know how we could bring it back by drawing a line. I think the better way to bring it back is just by saying, here are contexts where you really don't need to use this procedure. You can use your better normal merits procedure.
Well, but how would you define those cases? I mean, do they have to define them, or could there be examples where this should have gone to the merits, this shouldn't have gone to the merits, so that there would be guardrails there?
Yeah, no, it's a fair question, Congresswoman. I don't have a great answer. I mean, I think this is where I think I do agree with Professor Morley. I think the court really should be thinking about certiorari before judgment more often as a way of getting merits cases to the court faster. You know, I think requiring mandatory direct appeals, Congresswoman, in cases in which you have an execution set, in cases in which you have a death sentence, Congresswoman, perhaps in cases in which a district court has entered some kind of universal or defendant oriented injunction, and it's been affirmed by the Court of Appeals, requiring the Supreme Court to take that quickly. I think, you know, one of the ways to do this is to speed up the court's merits docket, which is, I think, unquestionably something Congress has the power to do.
Okay, thank you very much. My next question is for Solicitor General Ali Khan, and this is about these close cases where the dissent has found to write, the majority has not. And could you tell about how that affects the state of the law, whether that dissent seems to have more weight because somebody went to the trouble of putting it in there? How would you assess whether this should go forward, or whether we're really just leaving people hanging where we have a dissent but we have no majority opinion?
Congresswoman, you cut out a bit, but I understand the question to be situations where you have a dissenting opinion but not an explanation of a majority. So I think in those circumstances, you are only relying on the dissent to try and read the tea leaves to determine what the majority was thinking. And so that can be quite problematic. And so to go back to the COVID California cases, you know, it could very well be that the majority or the votes that comprised what was ultimately the majority, you know, were concerned about differences and how churches were being treated than from how restaurants were. But, you know, that doesn't, if they don't say so, how do we know? Right. And so then how does a jurisdiction that might have, you know, a full ban on any kind of indoor activity because they have very high COVID numbers, would they be able to think that there was a litigation risk associated with that? And how could they assess, you know, their need to balance public health against any potential litigation? And so when you're really just guessing, it makes it very hard for lawyers, especially lawyers for state and local governments, to do the real risk assessment of, you know, what do we do to protect public health at the same time minimizing any risks of any kind of litigation.
The gentle lady's time has expired.
Thank you very much.
I thank the gentle lady. Thank you. Thank you. And now we will turn to the accomplished gentleman from Oregon, Mr. Bentz, for 5 minutes.
Thank you, Mr. Chair, and incredibly interesting conversation. I really don't have any focused questions, but I would like Mr. Morley to take an opportunity, if he would like to do so, to expand upon his last several answers, if he wishes to do so.
Thank you very much, Congressman. One of the reasons why, as Professor Vladek had referred to, certiorari before judgment, right? One of the things that distinguishes that from the other aspects of the shadow docket is that once the case is before the court, then now the court has a full dress hearing, so to speak, right? There's the opportunity for merits briefing. There's the opportunity for amicus briefs, oral argument, written opinion, right? You know what justices signed on to the majority or the dissent. So it might be worthwhile, right, unpacking this concept of shadow docket to treat certiorari before judgment, right, differently from some of the other types of orders that the court grants. And again, right, as I had alluded to earlier, that's consistent with the legislative history underlying the court's current jurisdictional structure. The Department of Justice, in lobbying for our current jurisdictional statutes, emphasized the ready availability of certiorari before judgment in constitutional cases. As I mentioned, this committee emphasized the importance of it. And in a previous reform in the 1970s, when Congress began the process of repealing the mandatory 3-judge court requirements, some of the direct appeal as of right requirements, the Senate Judiciary Committee similarly pointed to the availability of certiorari before judgment. One point that I would also bring up as this committee considers possible alternatives. Throughout the 20th century, we had direct appeal as of right to the Supreme Court throughout much of the 20th century in constitutional cases, right? If a lower court, whether it upheld, whether it struck down a state law, a federal law, those cases were appealable directly as of right. It was because of concerns about the court's caseload that Congress repealed repealed those jurisdictional grants, shifted constitutional litigation to the ordinary appellate docket. And so in considering ways of reforming the shadow docket, one concern would be to not return to the system that Congress self-consciously brought us away from. One final point.
Would the gentleman allow me to interject with Ms. Sparks waiting for someone to yield? Would the gentleman see fit to yield some moments to the gentlelady, Ms. Sparks?
Of course. I so yield.
At your discretion, sir.
Let's how much time do we have left?
You've got about let's see. Yeah, about 2 minutes.
Okay, let's take another 30 seconds with our witness and then go to Ms. Sparks.
Thank you.
The one final point that I had wanted to quickly add is one aspect of defendant-oriented injunctions I didn't have a chance to allude to. If courts can issue these nationwide defendant-oriented injunctions, it doesn't matter how many times the government wins. The government can win 4 cases in a row, 9 cases in a row. When a plaintiff loses, that doesn't stop other plaintiffs bringing the same exact claims, and yet all it takes is one person to win anywhere, then to be able to get an order that shuts down the law or the executive order across the entire nation. So they involve a fundamental asymmetry.
Thank you. Yield to Ms. Sparks.
Thank you, Mr. Chairman. I actually don't have any particular question, but it's interesting discussion. I learned a lot. I was actually very surprised with the recent case that happened with, in Pennsylvania related to election and constitutional extension by the Supreme Court, that actually our Supreme Court has procedures. So it's a very good learning process. So I will yield back to Representative Benson if he has specific questions. I think it's an important discussion. I appreciate it.
Thank you.
Thank you. I have no further questions. I yield my time back to the chair.
Okay, I thank you both. And with that, we are at the conclusion of today's hearing. I want to thank the panelists for attending and for your testimony. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And with that, the hearing is adjourned. Thank you.